rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free.
$18680. I'm Judge Mark Kappelhoff. I'm present in the courtroom. The other parties are present here as well. Let's continue with introductions with the Special Assistant Attorney in this matter.
Thank you, Your Honor. Good morning. Sorry, good afternoon. I'm Sherry Townsend. I am a Special Assistant Hennepin County Attorney appearing on behalf of the state.
All right. On behalf of Mr. Burrell.
Your Honor, Paul Applebaum, along with Nico Radkowski, here on behalf of Mayan Burrell.
All right, and good morning to all of you. All right, we're here for purposes of sentencing in this matter. Let me begin first with the pre-sentence investigation. Have the parties had a chance to review the pre-sentence investigation? Have they received it and have they reviewed it?
Yes, Your Honor, on behalf of the state, and I would note for the record that Holly Neubauer, who prepared the pre-sentence investigation, is present in the courtroom seated to my right.
Ms. Neubauer, I apologize if you'd introduce yourself.
Thank you, Your Honor. Holly Neubauer with Hennepin County Probation. I authored the pre-sentence investigation.
Thank you for your thorough PSI you submitted back on November the 8th. Do you have any updates since submitting the PSI in this matter?
Mr. Burrell appears to be doing quite well on DHM.
All right, very well. Thank you. All right, and then to the parties, have they received the PSI? Have you reviewed it, and are there any additions or corrections?
Your Honor, I got the PSI this morning, to nobody's fault but my own. It's very short, so Mr. Burrell and Mr. Radkowski and family members went over it in a conference room. We have a couple comments, maybe corrections, I don't know the right phrase, but just to kind of amplify some of the issues in the PSI, which I'd like to talk to you about. But as far as the core facts in the case, his criminal history, no changes or objections.
All right, very well. Ms. Townsend?
Your Honor, I do not have additions or corrections, and I am prepared to move to sentencing.
All right, very well. All right, I will turn to you, Ms. Townsend. Any either testimony and or request for restitution initially?
Your Honor, no request for testimony. There's no request for restitution in this matter. I would just note that I did receive the PSI. It is, from my perspective, accurate in its determination that Mr. Burrell does face what we refer to often as a mandatory sentence of 60 months for count number 1. This is a felon in possession offense, and he has a prior conviction for which 609-11 was applicable, that being the conviction of murdering the first-degree crime committed for the benefit of a gang. I don't believe there's been motions filed as it relates to what the appropriate sentence is in this matter, because I don't want to speak for Mr. Applebaum, but I do believe that the law doesn't really permit for any departure without there being some appellate concerns in this matter, and that it does require a 60-month commit to the Commissioner of Corrections. So that is what the state is requesting in this matter. That is what the law requires in this matter. I would also note that count 2 would also be sentenced presumably, which, given his criminal history and what severity level it is, calls for a 19 months aid sentence. I will defer to Mr. Burrell and Mr. Applebaum as to what, if any, wishes or requests there are related to count 2, but we would request that same sentence in this matter.
All right. Thank you for that, Ms. Townsend. Mr. Applebaum.
Your Honor, as to count 2, I think you have to sentence, I think it's appropriate to sentence him on count 2 as well. We have the same appellate issues for count 2 as we do on count 1, so I think that's the cleanest way to handle that particular issue, is just to proceed on both of those.
All right. Okay. I'll hear anything else, Ms. Townsend?
No, Your Honor, I certainly would like to respond to any comments from Mr. Applebaum regarding his application to stay the sentence pending appeal, but I think given the status of the law and what the law requires in a circumstance such as this, the main argument for the court is Mr. Burrell's appeal, or application, I should say, to stay out of custody pending appeal, and I'd like to be heard on that after Mr. Applebaum has a chance to make any additional comments he had made. But I think we all agree that that would have to happen after the court imposes sentence.
I think that's right. You agree with that, Mr. Applebaum? Okay. Okay. Thank you for that, Ms. Townsend. All right. I'll hear you, Mr. Applebaum. Anything in addition you want to add regarding the sentencing?
I want to make some comments on the PSI, Your Honor.
All right.
And these are comments that Mr. Burrell concurs with, and it was his suggestion, and I completely agree that we point these things out to you. Now, even though it may not affect the sentence that you're about to give him, it sort of blends over into our motion that he remain out pending appeal. There's really no clean way to do this, and they're sort of the same issues, I think, and so.
I'm comfortable with that.
Okay,
That's fine.
so really the biggest issue that I have and Mayan has is the description of marijuana use in this case. Mayan's recollection is that one of your conditions of release is that he not use illegal narcotics, drugs. In his mind, and I think it's a reasonable mistake, if it was a mistake, is that marijuana is not an illegal drug when used, for personal use. He had 2 UAs that came back dirty out of, I believe, maybe 10 or 12. So not trying to excuse it, not trying to minimize it, but all of us are in criminal court every day, and we see that marijuana use is not, people's hair is not on fire because someone comes back with a dirty UA. He got that under control. I think everything's gone well. As the PO said, he's since some of these baubles came to light, I think he's done very well. What I would like to point out is that Mayan is a worker. Mayan has always wanted to work, and it's been tough to find a job, as one could imagine, with this kind of criminal history that he's got, even though he's working to undo that. I know you've gotten letters from employers who talk about what a dynamite worker he is. And if you know how to get out of bed and go to work, you have potential. And what he has done, coming back from the psychological setbacks that he's come back from, to stay focused, to come to work, to be positive, to get the kind of letters that he's received and passed along to the court, I think is fantastic. And I think it's a predictor of how he's going to conduct himself while he's on release pending appeal. There just is no better indicator in my mind of someone's success on probation, I guess, for lack of a better phrase, even though he won't be on probation. I think he's going to do great. He's going to get 60 months. He knows he's going to get 60 months. He came back to court today and the other days knowing that he's looking at 60 months, and
The only issue is whether you're going to let him stay out and continue at these jobs pending appeal. I think it's an easy call, Your Honor. I do. He's on EHM. He's been compliant. He's got, look at the support system he has here to make sure that he behaves. So I think it's, and frankly, if he's dumb enough to do something illegal or not comply with probation's requirements or whatever conditions you impose, then he's on his own. There's nobody that can bail him out at that point, including the court. So I think it's an easy call. He's been a tremendous client. We talk all the time. We have meetings. He's very bright. He's pretty traumatized, though, from what he went through as a young man. But he's worked through it. He has his bad days, maybe his bad weeks, actually. But sort of relative to what he's gone through, I think these things are minor baubles that can be corrected. And you can give him the benefit of staying out and working at these jobs, making money, supporting his kids, and maybe sort of become a credit to his community, which I know is what he wants to do. So I think it's an easy call, Your Honor. There are 3 witnesses that he would like to approach and tell the court the sort of network that he has around him to keep him on the straight and narrow. If the court is willing to let them speak for a minute, that would be much appreciated. They're not victims in this case. I'm not trying to, we don't have a right to have these witnesses come and speak to you, but I would ask indulgence for that.
As I mentioned in chambers of both of you, I like to hear from everyone, so I will take in any information. Ms. Townsend, do you have any objection to that?
No, Your Honor, I did note that in chambers that is the court's discretion. I agree with Mr. Applebaum. It's not necessarily a right articulated under the rule, but you have the discretion to make that determination. So I'm not going to do any kind of formal objection to that. I would like to clarify if you'd like to hear from the state as it relates to the application for his stay pending appeal now, or would you rather wait? I know there was a significant amount of argument from Mr. Applebaum on that topic. So
Yeah, I mean, I want to hear from the state regarding that. I guess you're folding both the sentencing argument and your application argument into the same.
Unless you want to hear the same argument twice. So.
However you want to structure it, I'll leave it up to you. And as far as hearing from members of the community or people that know Mr. Burrell, I'm always happy to hear from members of the community.
Right, and if we could, I think they can be heard together, and we would just rest after that.
That's fine, and I can handle both pretty much at the same time. Do you have any problem with that, Ms. Townsend?
no, Your Honor.
Okay.
That's not a problem at all. As it relates to Mr. Applebaum's comments about the PSI, the notation about use of marijuana, I don't necessarily note, and Ms. Neubauer can certainly speak for herself, but I don't necessarily think that those results were somehow indicative of why a sentence, which is mandatory under the law, was being recommended. I think it was just noted as part of the results of the test. She did note to me that instead of 2, there were 3 positive tests, but other than that, I don't necessarily know that that was something being relied upon as some sort of a basis for the 60 months. And if Ms. Neubauer has more to add, I can certainly defer to her.
Ms. Neubauer, do you want to speak to that issue? I think you're referencing, Mr. Applebaum, on page 4 of 6 in the pre-sentence investigation report.
And I'm not mentioning those things as a mitigation or an argument as to sentence, just as to the release conditions, Your Honor. So just trying to put those in context, not that it has any application to an executed sentence or a state sentence or anything like that.
Okay. Do you want to speak to things?
No, Your Honor, I don't have any additional comments. It was simply information to provide to the court as it relates to his substance use history.
Okay. Thank you for that.
And if I could ask, Your Honor, if Mr. Applebaum or Mr. Burrell have any other PSI concerns before I do any kind of a response, I'd sure appreciate that.
That's not even what I was talking about. What she said, I said I wasn't.
Okay, I think we're good. I don't think that's that big of a deal, but I'll definitely point it out. Anything else? No? So, minor point, well, not a minor point, but a point that we wanted to correct, Your Honor, is when he was speaking with the probation officer, there is a quote in there that he's not a felon, he's a convict. And I cannot see Mr. Burrell making that kind of I mean, it's a very harsh statement to make, and he says there was miscommunication there, and he might have meant something else, and so I hope the court doesn't put too much, and I'm trying to get you to the right page.
Page 2.
Yeah, on page 2, in the second paragraph, right at the very end.
Yeah, in the defendant's version. I hope the court doesn't put much stock into that. I think it's sort of an, if that's the way it was said, I can assure you that's not what was meant, because Mayan takes his situation very seriously and is not being flippant about how he's arrived at this position, even through the first case that he went to prison on. So, I don't know, it kind of jumps off the page, but I cannot see how that's how he would intend it to be. So, that's all I've got on that. Well,
We would have to go through this the first time I read this before, so we have to go through the whole. We have to go through.
the longer time does it say? So you're saying
And I wasn't, and also, yes, I said I was going to get a question.
Okay. So, Your Honor, I think on page 5, the second paragraph, the first line of that paragraph says, the defendant believes he is being penalized to the furthest extent while awaiting sentencing in this matter. I think what he tells me he was referring to there is that there are mandatory minimums in his case, and they can't be deviated from, and that's just the nature of what he's been charged with. So I'm not sure that it's a complaint. It's just stating that he understands the seriousness of his situation.
Ms. Newbar, do you want to, you drafted this, do you want to make any comments regarding the statements in the PSI, or the quotes in the PSI?
It does not benefit me in any way, Your Honor, to make anything up as it relates to what Mr. Burrell and I spoke about, and so that was a statement that he provided to me at the time that we met.
Nobody's saying it was made up, just putting it in context. So I hope you didn't take it that we're saying you're fabricating things. It's just, I think he's trying to say this is what I meant when I said that. So I don't want to fall into that trap. And I can't believe that he would mean anything different than what I just pointed out to the court. So, and the other thing too, Your Honor, is, and I didn't have a chance to confirm this, but he was convicted of second-degree murder. Yeah.
Ms. Newbar?
Your Honor,
Or, Ms.
for the record, it's Sherry Townsend, and I believe it's pretty clear from repeated records that he was convicted for first-degree murder for a crime committed for the benefit of a gang. I believe that was the exhibit that was submitted. I believe the court made findings related to that in its verdict.
It was committed to second rehabilitation.
Oh, I got, yeah.
I think the sentence, as a life sentence, would have to be the first-degree benefit of a gang.
But Mr. Burrell's telling me that it was commuted to second-degree murder.
Well, his sentence was commuted, Your Honor, for sure, but the initial conviction was for murder in the first degree for a crime committed for the benefit of a gang.
All right, I understand. Okay. So the sentence certainly was commuted back on December 15th, 2020. That's correct.
Yes.
All right. And then he was unsupervised released until November 23rd, 2022. That's all accurate.
Yes.
right. Anything else in the PSI that you would like to draw my attention to or make any additions or corrections to?
Mr. Burrell is telling me no, Your Honor.
All right. I want to, if Mr. Burrell would like to speak, I want to hear from him, but obviously, Ms. Townsend, I want to hear from you as well. I'm just trying to contemplate the order, and then we have some, apparently some witnesses that would like to also share their thoughts.
Your Honor, as it relates to hearing from Mr. Burrell, given that he does need to be sentenced before the application for release pending appeal could be considered, my thought is that allocution, at least on the sentence, is appropriate before moving to the next step, since the law requires he have an opportunity to allocute before a sentence is imposed.
That's certainly my preference. Mr. Applebaum, do you have any problem with that?
No.
Okay, so no more additions or corrections to the PSI. I don't know if there's any response from either Ms. Townsend or Ms. Neubauer regarding the, I guess, items raised by the defense.
No, Your Honor.
Nothing from the PSI, Your Honor.
Now, if you're, anything Mr. Burrell would like to share?
How you doing, Your Honor?
I'm doing well, thank you, sir.
I just want to come to you. I want to thank you for even considering allowing me to stay out in the community and work and actually be a productive member of the community, you know what I mean, while this appeal is pending. In the PSI I was reading, today is the first day that I ever that I actually read the PSI, so that's why me and Applebaum, me and Paul was going back and forth as far as my understanding of it, because a lot of this stuff, like when I spoke to her, she was actually calm when I spoke to her, and she had asked me about my experiences as a child, and I explained to her that the majority of my childhood was spent in prison, and that I had spent actually the majority of my life in prison prior to the crime that I'm in front of you for today. And so in that time, a lot of things took place, a lot of traumatic experiences, you know what I mean? And even going over them with her, it was like having to relive those times and go back into those spaces mentally. And some of it was traumatic and some of it was painful. So the way that I might have conveyed those stories to her, it might have seemed as it reads on this paper, but I was actually trying to explain my life experience in a short period of time. And with that, I just want you to know, I mean, because it didn't really say too much about my desire to do positive, to do good in life, and not just for me, but as a member of my community, for my family, for my loved ones, you know what I mean, for everybody that's around me. Like, I actually want to take my life experience and make it to where somebody else could benefit from it. Not to minimize what I'm in front of you for today. Like, I understand, I understand that it's a severe crime that I'm in front of you for, and it could be imposed 60-month sentence for me to go to prison. But I'm asking you to take it and consider it in your heart, you know what I mean, to allow me to stay home while I actually pursue this appeal and actually be a productive member of my community. Like, coming home after doing all that time, it wasn't easy, especially without a map on how to reintegrate back into society. And there's a lot of bumps in the road, and I take responsibility, you know what I mean, for every bump that I cause myself. But right now, I'm in a great space. Like, I've actually been striving and doing everything in my power to do what's right. And I'm in a good space. Like, I got 3 jobs that I'm working right now. And, I got mentees, I got at-risk youth that I actually identify with, that I'm actually mentoring and try to help to make sure that they don't make the same mistakes that I made in life, or actually have to go through the same life experiences that I had to go through. I've been working at the Legal Revolution, you know what I mean, trying to actually, you know what I'm saying, to get people on track of getting their records expunged. People who might have went through things a long time ago, you know what I mean, and right now with the Clean Slate Act, they're eligible to be able to have those reliefs, you know what I mean, and, as well as working at Tone Up. You know, I was working at Tone Up, lobbying, organizing, doing phone banking for the Back to the Ballot initiative and enabling more than 55,000 Minnesotans the opportunity to go out and cast a vote that previously didn't have an opportunity to do so because they had a felony on their record. And so with me, I'm trying. You know what I mean? I'm not a perfect man. I'm not a perfect human being, but I'm actually trying. and I believe that I can be a productive member of society and an asset to my community. So I'm asking you to take it in your heart to consider to allow me to stay home and actually do right. And if you do right, and if you do that, like, you'll never see me in front of you in court again, you know what I mean? Unless I'm doing something positive in a courtroom trying to, you know what I mean, get us to a different space. But like I said, like, I'm not trying to minimize anything that she wrote down or try to, you know what I mean, assassinate her character, say that she said anything inaccurate in the pre-sentence investigation. It's just the first time that I've read it. And I know that when I was speaking to her, what state of mind, and even having to explain those things of my childhood, like where it took me, and it took me to a place where, you know, I was actually that kid. So, like, you know, I didn't want to take nothing away from her either. You know what I'm saying? I appreciate you giving me an opportunity to speak.
Absolutely. Absolutely. Anything else you wish to share?
That'd be it.
Okay. Thank you for that.
Thank you.
Mr. Applebaum, anything further?
That says it all, Your Honor.
Anything further to say?
Anything beyond comments and the application?
Right, we can turn to that in a moment. Thank you for your comments, Mr. Burrell. Your sincerity comes through, and I appreciate that, and appreciate your statements. I've thought long and hard about your case and the sentence and the other issues here. And I note that after the commutation of your prison sentence on the murder case in December 2020, you were released from prison and essentially granted a rare opportunity of a second chance, really a new lease on life. And you were given an opportunity to be productive, meaningful, and lead a law-abiding life. And in many respects, you've taken advantage of that unique opportunity. And you've spoken to that. I've seen the letters. I've reviewed the letters, even one I received even today. I see the individuals in the courtroom here today, people you've impacted, and that comes through loud and clear. Your work at Tone Up this past summer through Election Day. You also worked at All Square, an organization I'm quite familiar with. It's an outstanding organization. And your lawyers, in the memo I received from them, shows that you impressed them at All Square so much that they've offered you a new position, or they intend to offer you a new position. And that's to your credit. You've been working for the past few months for another innovative solutions company, serving as a mentor to at-risk youth. And that's a huge credit to you. I think that speaks well of you, that you're sharing your experience to young people and talking about the road that you've traveled in life. You're still a young man, but you've obviously had some challenges. And I commend you for all of those efforts. And I appreciate all the individuals here who are in court today in support of Mr. Burrell. And that's certainly one side of the coin here. The other side, of course, is there's another troubling side, and that's why you're here today in front of me facing sentencing. And that is because you're going to be sentenced, or I will sentence you shortly, for the crime of possessing a loaded firearm with an extended magazine clip, which together contained more than 24 rounds of ammunition. And you were a prohibited person as a result of your prior conviction. And also a possession of drugs, a felony drug possession offense, where dozens of pills that tested positive for methamphetamine and MDMA were found in your vehicle. You know that. That's the case that's before me right now. And for unknown reasons, instead of maintaining the positive law-abiding lifestyle that you've described and that I read in the letters that you sent me since you're released from prison, you chose this other path, and I don't fully understand that. And that path involves criminal activity that impacts and endangers public safety. And that is the case that's before me now, not the other case. And as you know, after the stipulated evidence trial, I reviewed all of the evidence, and at the end of the trial, in August, I found you guilty of the 2 very serious criminal offenses, and you acknowledge that, and I hear you on that. And the first offense was possessing a loaded Glock 9mm handgun with an extended magazine as a prohibited person, and that occurred on August 29th, 2023. And you have a lifetime ban from possessing firearms as a result of the prior criminal offense. And that loaded firearm was found in the center console of the car, the vehicle you were driving, along with 24 rounds of 9mm ammunition. I also found you guilty of the felony drug possession, where you had 21 methamphetamine and 16 MDMA pills in the backpack, in the backseat of your vehicle, along with a digital scale and I guess 2 baggies of marijuana. I can't think of a single lawful reason why you would be driving around with a loaded firearm and illicit drugs in your car after being released and having your sentence commuted. But you did. The gun, the ammunition, the drugs were found in your car. You were the only one in the car when you were stopped by the police. You've shared your thoughts about that experience. I read the PSI, and I understand things can be misinterpreted, and I fully acknowledge what you told me here today about your trauma, your past trauma, being in prison and trauma as a child. I didn't see a lot of either remorse or accountability for your actions for having the firearm, the ammunition, and the drugs in your car. And that's a bit disappointing. I expected a bit more. You shared some here this morning or this afternoon, and I appreciate that. I don't know I wasn't the judge. I don't know the facts regarding the 2002 shooting for which you found guilty of, and you spent 18 years in prison for. And I understand you maintain your innocence of those charges, that you maintain that you're innocent of those charges, and you were not involved in those shootings. And I also understand from your attorneys that there's ongoing proceedings related to that case, and that will run its course. However, despite your claim of innocence and despite the commutation of your sentence for those convictions, you were in fact a prohibited person and can't possess firearms, and that's why I convicted you of that offense. And you didn't have a permit to carry the firearm either, even if that offense hadn't existed. And you certainly weren't in lawful possession of the illicit drugs. So I look at you as 2 sides of a coin, and I acknowledge the challenges you have faced in your life. And I've also acknowledged how you've attempted to be a role model and all these organizations that you've been working with, and how you're sharing your experiences and trying to work with young people, and that I give you a lot of credit for doing. But the 2 offenses before me that I have now convicted you of show that you engage in criminal activity, and that's what I found you guilty of. So that's what I have to balance. Probation, as you read in the PSI, had a fairly negative assessment of your future. I'm hopeful that probation is wrong. I'm hopeful that you have a bright future, or a future where you give back to your community, just like you described here to me this afternoon. But this is going to be up to you, with, of course, support from folks who are here in court today, and folks who probably aren't even here today who support you. But taking responsibility for your own actions, having the firearm in your car, the illicit drugs in your car, that would have been a good first step. I didn't hear that from you today. Did you want to share something?
I didn't want to interrupt you, but
Go ahead.
quite often people that are appealing their their conviction or their case don't want to talk about the offense facts. And so that's, I think, where that came from, not an avoidance of responsibility.
I appreciate that.
In no way was I trying to avoid responsibility for my actions. But when I was given a PSI, I was told specifically that I didn't have to speak about the underlying case because the case was on appeal. And so I didn't speak about the case because it was on appeal. You know what I mean? But in no way was I trying to minimize or not take responsibility for my actions.
Okay, I accept you at your word. Thank you. I appreciate that clarification. Yeah, that's helpful. And I'll deal with exactly what I found you guilty of, which is the firearm in your car and the illicit drugs, and that's what I'll be sentencing you on, and I appreciate your clarification, Mr. Burrell. Let me turn to the sentencing and the order in which I will sentence these will be with count 1 and then count 2. I think the parties have agreed, and I will sentence on both counts in this case, as the statute requires. With regard to count 1, Mr. Burrell, following a stipulated evidence trial, I have found you guilty as a prohibited person in possession of a firearm, and the judgment of the court is you are convicted of that offense. The court finds that a firearm was used in the commission of this offense. This is a mandatory presumptive sentence of a commitment to the Commissioner of Corrections for 60 months. Pursuant to Minnesota Statute 609.11, subdivision 8B, I have no discretion in this sentence. It's a mandatory sentence. I think we refer to it as a mandatory sentence, so there is no discretion the court can exercise in this sentence. I will impose the sentence and commit you to the Commissioner of Corrections, to the custody of the Commissioner of Corrections for 60 months, credit for 10 days that you've already served. Before any release from custody, you need to provide a DNA sample as required by law. You are prohibited from possessing firearms, ammunition, or ammunition for the remainder of your life. With regard to the fine and surcharge, I'll waive the fine and the surcharge as well as the library fee. That's with regard to count 1. Your judgment of this court is you're convicted of count 1. I'll turn next to count 2. With regard to count 2, felony 5th-degree drug possession. I previously found you guilty of that offense in filing a stipulated evidence trial. You have been found guilty by this court of 5th-degree drug possession, a felony offense, and the judgment of this court is that you are convicted of that offense. I will commit you to the Commissioner of Corrections for a period of 19 months. I will stay that sentence, execution of that sentence, for a period of 3 years. I will run that sentence concurrent to count 1. So count 1 will run concurrent to count 2. No fines or fees or surcharges in that offense. Probationary conditions will be obey all laws, do not possess, transport any firearms, ammunition, or explosives, and provided DNA as required by law. No use of drugs or alcohol and subject to random testing. I adjudicate and convict on both counts pursuant to Minnesota Statute 609.035, subdivision 3. That's why I'm convicting on both counts, because of the exception that is provided in the Minnesota Code. Any questions, modifications to the sentence I've just rendered?
Your Honor, I would just note that I don't know if you pronounced 2/3 and 1/3 on the sentence. If you did, I apologize if I missed it on count 1.
All right. With regard to count 1, you would serve 2/3 of that sentence and 1/3 on conditional release, supervised release, upon completing the 2/3 sentence.
And as for count 2, Your Honor, I will defer to Mr. Burrell and Mr. Applebaum relating to whether he wants to be on probation while he's serving a prison term, or if they want to demand execution concurrent with that. I think that's really up to them. So.
Yeah.
I've spoken with Mr. Burrell, and he would like the court to execute the count 2 along with count 1, if I'm using the right verbiage on that, just so that they're running concurrent, Your Honor.
Okay, I think I've ordered them concurrent, but any problem with that, Ms. Townsend?
No, Your Honor, I think that if this application for the stay of appeal would, or the stay for appeal would be applicable to both counts. So I think that makes sense to me.
All right, I will then execute that sentence concurrent. So in count 2, just to be clear, again, the judgment of the court is Mr. Burrell's convicted of the defendants. My sentence will be an executed sentence of 19 months to run concurrent to count 1 with no probationary conditions. It will simply run concurrent to count 1. All right, anything else regarding the sentencing?
I'm sorry to be a stickler, Judge, but I think since you executed that sentence, I think you probably have to say 2/3 and 1/3 on that as well. If I'm wrong, I apologize.
Any objection to me doing that, Mr. Applebaum? I think if the first sentence will be 2/3 will run longer than the first 2/3 of the 19-month, but I certainly can impose it that way.
No objection.
All right, you need to serve 2 months, 2/3 of the 19-month sentence, and 1/3 will be served on supervised release.
Thank you, Judge.
All right. Let me turn now to the application for release pending appeal that you filed, Mr. Applebaum, and I'll hear you on your motion.
Your Honor, as I indicated, and I have 3 people I'd like to talk to.
Yes, for sure,
I
absolutely.
just want to make sure. I think this is an easy call for you, Your Honor. There were some bobbles in the road, not trying to minimize any of that, but I think the situation has stabilized and things are looking good. Mr. Burrell has his own apartment now. He's working full-time, as I indicated, during my sentencing allocution. And look at the number of people that have shown up to support him. In addition to having a job, another important indicator of how someone's going to do while they're out on release is the support system that they have around them, people that can hold him accountable. And I am always pleased when I hear him talk. The insights that he's gained over the course of his life, are quite impressive. And he acknowledges he's a broken person, but that doesn't mean that he can't continue on his path. Very few paths are straight line. The things that happened in May are not good. No one's saying that. But I think that those are behind him now, and I think he's going to be productive while he waits to see what the Court of Appeals is going to do. And so you have 3 questions to answer. One, is the appeal frivolous? It's a dispositive issue in this case. If Mr. Burrell prevails, case is over. If we don't prevail, he's got to turn himself into prison. He understands that. He's been to prison. He hasn't run. He hasn't done anything to sort of evade the process. So the appeal is not frivolous, and I don't think anybody can argue that it is frivolous. The other question would be, is he likely, and the burden would be on the state to show this, is there a substantial risk that he's likely to intimidate a witness, commit a serious crime, or subvert the administration of justice? That's one of those legal rules or statutes that has a double negative, and it's sort of hard to parse through, but I think you have to decide that there's a substantial risk that he's going to subvert the administration of justice. There are witnesses in this case, but this is a victim. I think you understand what I'm saying when I say it's a victimless crime. We all know that it's a societal risk that he presented by having that gun in his car. But there isn't a specific witness that could be influenced, intimidated, that there could be retribution or anything like that. So you don't need to be worried about anything like that. He can't tamper with evidence subverting the administration of justice. So that's not a risk for you to take on Mr. Burrell. As I mentioned, there's no risk he's going to intimidate witnesses. The only witnesses in this case are law enforcement. not a risk. Committing a serious crime, I think that's the thing that requires the most thought. He's got some work to do. He's got to rebuild the trust. I think he was doing great, and then he catches this case that you're presiding over, and then he had the case with the 5th-degree drugs this summer. I think he's done a lot to redeem himself. I do. When you consider what this young man came out of prison like, I think he deserves a pat on the back. And maybe people will roll their eyes when they hear that. But think of the horrors that he's been through. And it's not a straight path, Your Honor. But I think he's developing the insights, as he showed you, that he's going to behave himself while he's out on appeal. The dumbest thing that he could do would be to catch another case. The appeal wouldn't matter if he caught another serious case. He'd have to deal with the new case. So I really do think it's worth a shot. He's worked hard. His friends and family have worked with him. I worked with him to try to understand what needs to be done in order to stay out. And we're really not talking about a long period of time. I would say maybe 18 months max. He's got the apartment. I already talked about that. He's got the job. I think he's going to flourish. He just needs the opportunity. And why make him go into prison when he might prevail in the appeal and beat the case entirely? So you have tools that you can use if this doesn't go the way I predict. All you have to do is yank him back into jail, be done, and wait for the appeal to run its course. So all those things taken together, I would ask that you let him stay out. I don't think you're going to regret it. That's all I have.
All right. Would you like to call your witnesses?
Sure. Your Honor, the first one is Eliza Darris. Is he here? Could you step forward, sir?
And just so for the record, Ms. Townsend, Mr. Applebaum, I know Mr. Darris. We've worked together. Yeah, if you just come up here, we know each other. We've worked together on other criminal justice related matters.
Your Honor, I don't know the right format to use. Can I just ask him to tell you briefly what he wants to tell you? Is that?
Sure. Ms. Darcy, would you just tell me your name first and spell it?
My name is Eliza Darris. That's E-L-I-Z-E-R. Last name Darris, D-A-R-R-I-S.
All right. Mr. Applebaum, do you want to, I could just ask Mr. Darris to tell me what you'd like to tell me, or however you want to handle it.
That's fine, Your Honor. Thank you.
Okay. Good morning, or good afternoon now.
Good afternoon, Your Honor, and thank you for allowing me and other advocates or family members to speak on Mayan's behalf. We recognize that you did not have to do this, and so we really do appreciate it and value it. I've actually known Mayan for many, many, many years. I, like he, was a juvenile lifer. I was sentenced to spend the rest of my natural life in the care of the Commission of Corrections. Unlike him, I got my life sentence reversed on appeal, resentenced to 2nd-degree homicide, and I served another decade inside of this. I had a lot of runway to prepare myself for an eventual release, and I was really fortunate. It was challenging at first, but I was really fortunate to ultimately be surrounded by some really fantastic mentors, men and women who really poured into my life to really allow for me to really stabilize and ultimately flourish. With Mayan, it was a pretty instantaneous release back into the community, and many of us, have just been grinding and grinding and grinding, fighting for justice, trying to establish our lives, building families. And I recognize that the community of support that we probably could have and should have provided for Mayan, I think that the most glorious thing was really fighting to get him out. But then there's a secondary component to that. There is an accountability component. There is a support component that Many of us within the advocacy space, we recognize that because all of it was new to us too, we didn't provide that secondary level of support for someone having such a dramatic shift and a dramatic change in their lives. Mayan really needed more of us to come around to really help him transition back. I had a transitionary period, right? I went from super maximum to medium to minimum to home. That was my process, right? And that wasn't Mayan's process. Mayan's process was to go from Stillwater Prison, which was a level 4 prison, home, like that, right? But I watched Mayan come into the prison as a child, quite frankly. I was in the juvenile program as well. I was a little bit older than him, and he was one of the tiniest people within the facility. But he had bright eyes, and many of us within the facility, we recognized his intelligence. We recognized a lot about him that we saw that was good. And quite frankly, it became really well known. I know that this is still at issue and that, other determinations and other proceedings are still being determined, but it became really well known that he wasn't guilty of the offense that he was inside of the prison of. And everyone, it's sometimes the street just knows, and this was a situation in which the streets just knew. And ultimately, I think justice really ran its course, and he was released. One of my great regrets is not being, as present as I recognize I could have been and probably should have been. I just, I recognize how much support I had. Like, I've had mentors in the prison who was released, who was there with me. I mean, my first car came from Willie Lloyd, who he gave me the first car, for $1, right, and was ever present, ever holding me accountable. I could ask like some of the really challenging questions around, relationship issues, family issues, job issues. But I think a lot of that scaffolding, many of us recognize we probably could have come in and helped to provide for him and others, not just him. I think that there's been within the advocacy community a shift. So there's been other young men who have now been released. That level of support is there, right? We've recognized, okay, it's not enough to just fight to get people out, right? We then have to also provide, the supports that is necessary to help people come back home. And with Mayan, particularly over the past few months, I've been present. I've been there. I mean, just the other day, my wife made some chicken noodle soup. I took it over to his house. He's right across the street from All Square, and we kicked it. We got a chance to really chop it up. We talk, at least every other day, most of the times daily now. I'm present. I'm there, right? There is support mechanisms. There's scaffolding now around him, right? And the other case is working. I'm also part of the CRU, and I recognize some of the challenges that we've had moving cases through the processes. We're almost there, and so what I would ask for you, Your Honor, is to recognize the community that is around him, that is standing up to say, we will stand into the gap. We will be inside of the gap. We are here. We support him. And we will continue to be ever present. I have seen such a dramatic shift inside of Mayan within the past few months. It's been really remarkable. In fact, and I'm here, and we know each other a little bit, and you know that I don't really skirt around the gray areas. I'm pretty, and I'm here to offer him that level of support that is really needed for someone like myself who was a young person coming back home to this community. And so I would just ask you to allow Mayan to stay in the community with us as this instant appeal works its way through the process, and then the other case as well works its way through the processes as well. And so that's all I would have to say, is just to come forward and just to offer myself up as a pretty committed supporter and mentor of Mayan.
Thank you for that. Thanks for sharing that. Thank you.
Your Honor, the next individual will be John Geffen.
All right. And just, I think we discussed this in advance. Television cameras are rolling. I just want to make sure that you're comfortable having the television cameras running. If you choose not to be seen, you just let me know.
Thank you, Judge. And I'm fine with the camera.
You're fine with the cameras. All right. If you
My
could,
name's,
yeah, go ahead. Beat me to it.
My name is John Geffen, Jongeffen. I'm an attorney, and I'm the director of the Legal Revolution Law Firm, and I'm also the director of the Reentry Clinic at the Mitchell Hamlin School of Law. And I've known Mayan for a while, just since his release, and I had periodic connection with him. Always enjoyed him, always found him to be positive, lovely human being. I guess it would have been about this summer, this most recent summer, he started working at All Square. And he started working at the food truck at All Square. Our organization, the Legal Revolution, is very connected to All Square. And so I started seeing him more. And I started seeing his impact on people around him. People like Mayan. Mayan brings a ton of positivity. Every time you see Mayan, he's going to hug you. And you're going to hug him back. And it's kind of one of the more wonderful things every day to see somebody and give them a hug. And so at the reentry clinic, I started seeing Mayan. I thought it would be a good idea to have Mayan come talk to the reentry class. The class works with the students, work with individuals coming home from periods of incarceration on civil legal matters. And matters like the perils and struggles of reentry. And Mayan came to class, and we actually joined 2 classes, and he held, you couldn't hear a pin drop in this class. The students were fascinated by it. It wasn't a recitation of every bad thing that happened to them. They're talking about what is it, the human parts of coming home after decades away from being a child to coming home as an adult, having parents have passed during that time, people you didn't get to grieve and bury, people who forgot about you, communities that moved on without you, family members that moved on without you. So the jubilation of coming home, but then the realities of being home. And he talked so honestly and thoughtfully about it. It was every student that we met with that day came to me individually and talked about the impact that it had on them. And a very positive impact. And not the Pollyanna stuff, just the perils of this reality of reentry. And I started thinking, if you can have that impact in one afternoon, what else could we do? And we decided to hire him at the law firm. And for the last month, I see Mayan every day. And I get to hug Mayan every day. And we go out into community, and Mayan helps. You know, it's not just he has a job. His job is perfect for him because he goes out into community and helps and talks to people coming home who need that support, who maybe he didn't have enough support. He makes his own decisions. But what I see now is him in community working hard, not for stuff that self-grandizes him, but makes other people's lives better. He excels in community. He has a history of lived experience that can bring him into a room and connect with people in ways I can't connect with those folks. And he does it earnestly, and he's good at it. I won't profess to know everything about all of his cases, but I know him now, and I know how he's viewed in community and how he's accepted. The community needs him. He is an asset to our community. He's an asset to young people, and he is doing good things. I hope he is allowed to continue to stay in community. The last thing I'd say is his apartment, and I think as Mr. Dare said, is right across the street from All Square. Mm-hmm. Everybody at All Square, he comes in. Those are 10 people that connect with him daily. Those are 10 hugs. I see him at the Legal Revolution very much daily. There's another 10 people. And we are there to support him and hold him accountable, and he's there to support us too. It's a very symbiotic, strong relationship. And I appreciate the court taking the time to listen to me today, and he's in good hands in community, and I appreciate it. Thank you, Judge.
Thank you for being here. Thank you.
Your Honor, the final witness that we have is Leslie Redman.
Hi, good afternoon.
Grace and peace, Your Honor.
Thank you. Would you tell
My
me?
name is Leslie Redmond.
Thank you.
Leslie, Leslie, last name Redmond, Redmond. Many people know me as the former president for the Minneapolis NAACP. I'm a licensed attorney. The list goes on and on and on. I do a lot of community work, and I'm really committed to our community. One thing I wanted to start with was what a lot of people don't know about me is I'm what would have been considered an at-risk youth from the inner city of Washington, D.C., first-generation college graduate, went on to do a JD MBA and so many amazing things. But because of that, I understand the gaps that exist within our communities. Unfortunately, I've lost 2 of my brothers to gun violence in the inner city of Washington, D.C., and countless others. And so I know of the danger of these weapons and these guns in our community. And I also recognize the danger that young black men face when they do not have any protection, right? I came across Mayan Burrell because of his case. People were bringing it to my attention about his wrongful conviction, and I advocated. And I was so thankful when it was commuted. I actually met with Senator Amy Klobuchar and was one of the individuals that was able to help her see the light and to advocate and help us to fight for Mayan's freedom as well. And when I watched him come out of that jail, that prison in December of 2020, I never imagined that we would be here today. And when you talk about accountability, yes, it's personal accountability, but as Eliza Dara said, it's also community accountability. And I want to echo Eliza's sentiments because at the time we were all exhausted. You know, it's also coming off of the summer of 2020. We know COVID-19, so many things existed with George Floyd, and the list goes on. And I don't think that we were able to show up for Mayan. So when you talk about that gap of like support and who he is now versus who he was before, it's because it was a real gap. You know, he was coming back to no resources, no real opportunities were there. When you're in situations like this, people want to stand away from you. They don't necessarily want to stand beside you, right? All of us that stand up here today, we're also putting our names on the line. We're putting our face on the line. And I started putting my name and face on the line with Mayan before I even met him in person, right? I never met him in person, but just because of his case, I believed him. But meeting him in person, such an amazing person. I was meeting with my dear friend Emily Turner, who's in the room today, who is the creator of All Squares and also Legal Revolution. And she said, you know, Leslie, how can I support you in what you're doing? And I said, to support me, you can support Mayan, right? Like, that's what I really needed. That's what was hurting my stomach, that I couldn't show up more for Mayan because I knew how much he wanted to do well. And this was after the incident happened. And it didn't make me want to stay away from him. It made me want to lean in more because I realized, like, oh, we kind of, you know, we messed up as a community by not wrapping our arms around him and supporting him enough, right? And so what you're seeing now, as Elijah said, is a product of us showing up for him and supporting him. And that's why I'm here today, because I do believe in Mayan, and I do believe he deserves a future, and I do believe that he believes he deserves a future. And I ask you to see his humanity. I ask you to see all of our humanity, and I know that you do, just of the way that you've been conducting this case. And I appreciate you for giving us opportunity. And I didn't mean to be up here crying, so I'm going to go now, but I appreciate you so much. Thank you.
You're very welcome. Thank you, Ms. Redmond. Thank you for your comments, and I'm sorry for your loss of your loved ones.
All right, can we just take, someone wants, we wanted to limit it to 3 people.
Can I speak to my son, Your Honor? That's my son. My name is Michael Tucson. I'm a father.
Sure.
I hear all these advocates talking.
If you could, sir, if you'd begin just by telling me your name and spell it for me, please.
Thank you for taking the time to let me speak. My name is Michael Tucson. I'm Mayan's father. And I own up and I take accountability because I'm the father that was in prison 10 years of his life while he was a baby. And so I am most of the blame of what happened to him. He has to own his own accountability. I understand that. I've been to court so many times and I watch people advocate for him, and but no one ever asked me or my daughter how it makes us feel to see my child go through this. You know, when I was recently getting out of jail in 2002, I served about 10 years. I went 92 and got out in 2002. His mother died while he was down there, going through his trial right here. And the media said, well, she died coming down there to see him. He has a lot of burden on him, and it's a lot of things in his life that really, really bother him. And my son and me, when he got out, I didn't even spend much time with him because of COVID and all the other things that was happening, but I know he was scared. He was scared of society, and I can tell you from going through being 10 years and walking out after 10 years for something I did, to actually walk out for something that you didn't do, and everybody in the world looking at you as you did this to this little young girl. And I'd like to put a name on her. Her name is Taisha Edwards. You know, and the baby did not deserve to die. She was at her table. And like Elijah was said, the streets talk. And so we actually knew my son didn't do it, and we fought. 18 years, every day. I went up to prison and seen my son faithfully. You could check the corrections every weekend, and if it wasn't a weekend I couldn't make it up there. It was because of something happened major. But this is hard, and what's hard for me is that what Leslie said, if you're not in the community, you don't understand how it is to feel like you walk out of jail and the people that think that you did something, they still don't care about what it was or what he didn't do, you know. And so at one point in time I was saying I'd rather for him to be judged by the 12 than carried by the 6. And if you don't understand what that means be killed by somebody out there in society, you know, rather than not be able to protect yourself. And I watched so many people get up out of jail after him, and they allowed him to get the rights back. And I know it's not no one in here's, but he has been calling me for the last 4 months. If it ain't every day, every other day. And as a father, I sense his fear. You know, I sense his fear. Fear going back in the box, fear going through the things he's going through. But also I know as a parent that it's hard for me to say I'm at fault for doing something wrong. But I know my child, and I know that he feels as if he could do it all over again. I watched him. I went over to the places that he worked at and watched him contribute. I'm talking to him on the phone. He's telling me he's with mentees. And the young kids need that out there. They truly need that out there. Because without somebody that experienced it or been through it, how can they not make the same mistakes that he was charged for? Not that he necessarily did, but that he was charged for. And so I would ask you, Judge, to at least know that we are here for him, and that we're not just saying it, and that I want accountability. And if it takes me talking to my child every day, and I'm proud to see that he got out and that he's doing something better, and if what happened to him allowed him to see that this can happen, I understand that he knows it now, and I hope that you would give him leniency, and that's all. That's all. And you know, the reason why I got up and spoke, because for years I watched people talk over my kids, and I had nothing to say. They never even asked me how I felt, or my daughter, which she goes through a lot with Mayan. And I just thank you for giving me the time to say that, and I really appreciate it.
You're quite welcome. Appreciate your words. Thank you for sharing. Mr. Applebaum?
Nothing further, Your Honor.
Ms. Townsend?
Well, Your Honor, I'll be candid. That is a lot to try and respond to and counter, and I will be candid with the court. I'm going to probably just rely mainly on the law as it relates to these applications for stays pending appeal. They're highly unusual, Judge. I think I've seen one in my career, and I think there's a reason for that once you've been determined to be guilty by a court of law in this circumstance, it's unusual to put off resolution or sentencing while an appeal is winding its way through the courts. I would note that Mr. Applebaum referred to a portion of this being the state's burden, and I would disagree with that. I believe that Mr. Applebaum does have the burden for the court to consider an application of a stay of this sentence that you just imposed pending appeal. I don't think the court will be surprised to learn that my concerns are primarily focused on the issue of public safety, as I believe they echo a few of your concerns that you mentioned during sentencing, Judge. We had as I think you referred to it as something, somewhat of a gift in a commutation of sentence in 2020 and a release from supervised release in 2022. And then this incident happened in August of 2023. And at that time, Mr. Burrell was aware that he had not been pardoned, his sentence had been commuted, and he was prohibited from having any gun, let alone that gun, with an extended magazine and multiple rounds of ammunition. So that, of course, is one concern for safety and the primary issue with this case. But while resolution of this case was going through the court system, Mr. Burrell picked up another case that is pending where he was found in possession of a pill in his vehicle. A search warrant was executed. It took him a long time to open up the car doors, and in the squad video there's appearance of trying to hide something during his detention in that matter. That's of concern to the state that happened, and certainly a new charge has been issued and that case is still pending. Also of significant concern, Your Honor, is the fact that after the court found Mr. Burrell guilty of this very serious offense with this firearm and these drugs in his car, and again, I think you clarified this on the record, Mr. Applebaum, I believe, said that the firearm was in a backpack out of reach in the pleadings, but that's not true. That firearm was found in the center console, and I know you watched the body-worn camera of that, so it was accessible. But after all of that, and after your determinations of Mr. Burrell's guilt, he was then found in a Burnsville parking lot on September 9th, having just ran into another vehicle, and with a .06 blood alcohol concentration and an open container of cannabis in the car. And that was even after the finding of guilt. As the court is well aware, I did ask the court to hear the state on conditions of release because of those public safety concerns that were ongoing. I understand from Ms. Neubauer that once the court did place him on EHM, as you did after that hearing, that he's done better. But that's been since October. This case has been going on since August of 2023. So I think the state's biggest concerns here, Judge, as you consider this application for release pending appeal, is the safety issue and the ongoing conduct while this case was pending, in addition to just this case existing in the first place. So the state does oppose the application for release pending appeal, and I appreciate the opportunity to make that record.
Thank you, Ms. Townsend. Mr. Applebaum, any additional arguments?
Only that if I implied or outright stated that it was the state's burden that there's no likelihood of serious crime or intimidating witnesses, I apologize for that. I meant that
The court has to make those findings, and I don't think that the court can do that. I think that this Burnsville case is a tempest in a teapot. It was a payable offense. He could have gone down and saw a hearing officer and gotten rid of it. So he's not even been convicted of that. So I don't even know how that's relevant to anything. And there's a motion to dismiss pending on that situation. I don't think that that's relevant. I think that the people that spoke on Mayan's behalf were incredibly eloquent and acknowledging that he didn't but now does have a safety net. And I'll say it for the fifth time. I think this is an easy call, Your Honor, and if I'm all wrong about Mayan and what his mental state is now, you can issue a warrant, yank him back in, and he goes straight to prison. So I just think there's no downside to doing this. And I won't just circle back and start repeating myself again. I think it's all been clear. And these witnesses were amazing. And I hope that you take what they say to heart. That's all I have.
Anything further, Ms. Townsend?
Nothing, Your Honor. Thank you.
I do, to your last comment, Mr. Applebaum, absolutely. That's why I wanted to hear from members of the community and supporters of Mr. Burrell, many of whom have been at other hearings here. And clearly he has made an impact in the community and as I noted during my earlier remarks, continues to make an impact in the community with young people in particular. And to me, that's quite impressive. And I acknowledge that, and I appreciate everyone here who's here and everyone here who came up to speak. And I know that's not easy, and you do it because you care about Mr. Burrell and care about the community at large. And I think that speaks well of everyone who's here. And I thank you for that. As a judge, every day I strive to treat everyone who walks through those doors fairly, equally, and equitably, to ensure that we have even-handed justice in this courtroom, every courtroom I preside over, and I also strive to do that not only in my courtroom but throughout the community and throughout our country. And that's what I'm doing here today. And my job is to apply the law fairly to everyone and equitably to everyone who enters my courtroom. and I will, of course, do that for Mr. Burrell. This is an application for release under Minnesota Rule of Criminal Procedure 28.02, Subdivision 7. I say that at the outset because there's specific statutory requirements I have to follow as a judge, and I'm obliged to do that and apply the facts before me to the law that is applicable to this circumstance, and that's what I intend to do. I will note at the outset the request is extraordinary, and it's rarely granted. I think Ms. Townsend noted that. It's an extraordinary remedy, and these requests are rarely granted. Under the statute, I will note there was a conversation about the burden of proof. As I read the rule under Minnesota Rule of Criminal Procedure 28.02, Subdivision 7, it actually reads, a court must not grant release pending appeal from a judgment of conviction unless the defendant establishes to the court's satisfaction, 1, the appeal is not frivolous or taken for delay, and no substantial risk exists that the defendant will fail to appear to answer the judgment following the conclusion of the appellate proceedings, and is likely to commit a serious crime, intimidate witnesses, or otherwise interfere with administration of justice. That's right from the rule itself. So let me deal with each of the parts of that rule separately. The appeal is not frivolous. That's an easy question for me to answer, and it's certainly not taken for delay. Another judge of this court presided over the suppression hearing in this case, over a contested evidentiary hearing on the defense motion to suppress the evidence back in February of this year, and the judge issued an order on April 29, 2024, denying the defense motion to suppress. I find that the legal issues raised by the defense regarding the expansion of the stop after the police stopped Mr. Burrell's vehicle on August 29th for several traffic violations, field sobriety testing, and his arrest and the subsequent search of the vehicle are not frivolous. And they're not subject to taken for the purpose of delay. So let's just put that aside to start with. So that condition is certainly not applicable. Then the next question is whether there's substantial risk that the defendant would fail to appear following a judgment after the appellate proceedings are concluded. Mr. Burrell's appeared for every hearing. I placed him in EHM. He has largely complied with EHM, as I understand from Ms. Neubauer. Of course, now you are convicted of this offense of the prohibited person possession of a firearm, and I've ordered you to serve 60 months in prison. That changes the equation a bit, but I don't necessarily see that you wouldn't appear following a judgment of the appellate court, so I don't think that is necessarily applicable. The other question is whether you would commit a serious crime, intimidate witnesses, or otherwise interfere with the administration of justice. Let me just address intimidate witnesses or otherwise interfere with the administration of justice. I don't think those are applicable here. I've seen no evidence of that. So in my view, the critical issue, and many of the witnesses who just testified before me spoke to this issue, is whether there is a substantial risk that Mr. Burrell is likely to commit a serious crime if he's released pending appeal. And the key question then is for me to assess whether the defendant has established to me, this court, to my satisfaction, that there's no substantial risk of the likelihood of committing a serious crime. So let's run through where the record stands. Again, applying the record before me as objectively and fairly as I can. The first case is the case you're here before me on. You've now been convicted of 2 very serious criminal offenses, the first of which is the possessing a Glock 9mm handgun with an extended magazine clip with 19 bullets in your automobile. And our community wrestles every day with the proliferation of firearms. And I believe, Mr. Redmond, you spoke to that issue and how these firearms cause so much damage in our community. In addition, it wasn't just the firearm. You also had 37 meth and MDM pills. And this occurred less than 3 years after you were released from prison. These are certainly serious crimes. I've spoken to that. There's no question in my mind they're serious crimes. And you've been convicted of both of those offenses. I believe that is evidence in this. I find that it supports evidence that you may be a substantial risk for committing future serious crime. That's what's before me. Those are the facts before me. Those are the facts I found when I reviewed all the evidence in this case, and I found you guilty of that offense. I'll note that that offense occurred just 9 months after being released from supervised release from the commutation of your sentence. And the words that were spoken here by the witnesses, I do take them to heart. I think Mr. Darris mentioned that, and I do. Your phrase scaffolding is resonated with me, and I hear you, and you all have spoken eloquently about that and how the scaffolding wasn't around Mr. Burrell, and that you're here today, and I hear that. I see that. I acknowledge that. The other evidence before me that I have to weigh is even after, Mr. Burrell, you were charged while this case was pending, the first case I just mentioned, the case I sent it to you on today, you then were charged with a felony drug case in 2024, just 9 months after the charges were filed in the first case. Another very serious case in which you were found in possession of a meth pill. I know there's an argument that's somewhat diminished. It's still a felony. It's still a felony. It's a serious drug offense. It's a felony drug offense in chunks of suspected controlled substance. And then there was a search warrant, and these are allegations, and I know they are allegations in these cases are pending. This is what was in the probable cause statement. A suitcase with $60,000 in cash in your home. So there's another pending felony drug case pending before me. I find that that is additional evidence in support of, or that weighs, the court has weighed and found that supports the fact that you may be at a risk, substantial risk of committing serious crime. It's pending. You're presumed innocent of that offense, but I believe I can take that in consideration in making the decision whether to leave you out on appeal. And then so that's just 9 months after the first case, so there seems to be a pattern here. And then the last one is the Burnsville traffic offense. I acknowledge it's troubling, but even after I had issued my order in this case, you picked up a new offense, and I understand they're, and Mr. Appleman, you aptly pointed out, they're not the most serious offenses, but they occur while 2 other cases are pending. So it's the third in a series, and there's a pattern. While it may not be serious, when you fold it into all the other aspects of Mr. Burrell, it provides additional support that creates a substantial risk. And then we have the case in which Mr. Burrell's been commuted, his sentence has been commuted. I think that also was a factor for the court to consider, and I understand it's been commuted and there's other proceedings that are pending that aren't before me, and the case may take a different direction, but it's another factor to consider. So This isn't an easy decision. Contrary to what you said, Mr. Applebaum, it's a very challenging decision. I hear from the community, I see the community here, I see who Mr. Burrell is, his history, and I don't diminish that. All the organizations, many of organizations I know quite well, many people I know quite well work in these organizations and who I have great respect for, have come forward. But ultimately, my job is to apply the law that I see based on the facts before me and assess whether there's a public safety risk and apply specifically the factors in Rule 2802. And I'm wrestling with that decision. Have wrestled with that decision. And when I balance all of these factors and weigh the factors and weigh the powerful testimony here today and apply those factors and the evidence before me to the rule, I find that Mr. Burrell is not established to this court to my satisfaction, that there's no substantial risk that he's likely to commit a serious crime, or I allow him to remain out on release pending his appeal. According to the rule and the way the rule is written and the way the burden is placed on the defense, I'm going to deny the request to have Mr. Burrell released pending appeal. And he will be taken into custody to serve the sentence that I imposed earlier this afternoon. And he's to begin serving his prison sentence pending the appeal that will be filed in this case. Again, I appreciate everyone's testimony, the arguments of counsel, and that is the court's decision in this matter.
Can I hug my brother? I'm sorry. I'm not talking to you guys. Can I hug my brother, Judge?
I love you. I love you. I love you, sir. I love you,
I love you too. I love you, baby.
Love you more.
Love you too.
Yeah, I'm sorry.
All right. Concludes these proceedings. We're off the record.
The system's rigged, man, it's time to break free. Eyes wide open, gotta see what I see. Standing on the front lines, fighting for the truth. Lift the veil of lies, it's time to be the proof. Take a stand, don't you back down. Raise raise your voice, let's shake the town. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. Marching with a purpose, we're taking it higher. Fighting through the struggle, igniting the fire. No more silence, we'll make the noise loud. Together in this battle, standing strong and proud. Injustice fades when courage aligns. Rise up together, break the confines. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. United and free. So rise up now, it's our time to shine. Together we'll write a new paradigm. You paradigm, you paradigm. Whoa, whoa. We're the voices that won't be ignored. Breaking chains, yeah, we're ready for war. With the power of the people, we'll make them see a world of justice, united and free. United and free. Rise up now, it's our time to shine. United and free. We'll write a new paradigm, new paradigm. United and free. United and free. United and free.